Hello everyone. So in this video, this is lecture 3 of our series of Indian Contract Act 1872. So in this particular video, our agenda is to discuss important cases. I'll discuss very landmark cases of the Contract Act, basically of the contract principles. Even before we had Indian Contract Act, there were a lot of principles which were already developed by the courts of UK, America during the common law system. So we will discuss those cases also and some Indian cases also. And why I'm discussing these cases is it's very important because in Indian Contract Act 1872, not everything is written. A lot of interpretation is involved when it comes to contract. So along with bare act reading, there is very important. It's very important for you to understand the cases, the principles, contractual principles, because these principles hold importance in every case. So you'll understand each case. We'll try to figure out what is the legal principles involved, and I suggest you to make notes out of it so that you remember the cases. I've tried to include pictures also so that you remember the cases. So let's start with the first case. The first case we have is Lalman Shukla versus Gauri Dutt. This case deals with importance of communication. Write this importance of communication so that you remember what this case involves. So what the principle of this Lalman Shukla versus Gauri Dutt is, in this particular case, Lalman was tasked to find Gauri's lost nephew. Gauri offered a reward for his safe return, but Lalman was unaware of the reward. After finding the nephew, Lalman learned about the reward and claimed it. So in this case, what happens is defendant's nephew, defendant's nephew, he absconded from the house. Like वो घर से भाग गया. And what the defendant did? Defendant here in this case is Gauri Dutt. Gauri Dutt sent his servant in search of the boy. उसने अपने servant को भेजा for the search of the boy. And when the servant left, Gauri Dutt, the defendant over here, he had offered to pay rupees 501 rupees to anyone discovering the boy. So here what he did, he made a general offer. What we call this offer is general offer. Why? Because he is making the offer to the world at large. Whoever finds finds the boy, he'll get 501 rupees. The servant came to know of this offer only when he had already traced the missing boy. The servant had already traced the boy, and when he came to know about this offer of Gauri Dutt, he claimed the offer. He brought an action to recover the award. What he did, he brought action to recover the reward. I know you can't see it, but I've explained you in a very easy way that what happened was the servant came to know about this offer later on, when the offer has already when he had already found the boy. And what the contract was, the performance of the contract was based upon finding the missing boy, and he filed the case against Gauri Dutt to claim rupees 501. So this is what the gist of the case is. It's not very complicated case. So what the court held in this case? The court in this particular case held that there was no acceptance. What the court held? The court saw this case. The court said there was an offer by Gauri Dutt, but there was no acceptance in this case by the servant before he fulfilled the the condition. So this means basically there was no contract between the parties, because in order to constitute a contract there must be an acceptance of an offer. Acceptance of offer is an essential ingredient to constitute an offer. So this is particularly this case is about. So what the legal principle involved in this case? A valid contract requires both offer and acceptance. Lalman was unaware of the offer, so his subsequent performance did not constitute a acceptance. His performance of the contract will not constitute the performance if he did not know the offer itself. So there was no contract in this case. So this is a very landmark case when it comes to importance of communication. If you get this question, you should know this principle, and you should be aware about how to use this particular legal principle while solving your contractual case studies, or like understanding this principle. I hope I was able to make this clear. Let's move on to the next case. Next case is Jones versus Patherton. Intent to create a relations and family agreements. In last video, I covered the Balfour case. Balfour case, where I had dealt with the concept that when in the contract there is a requirement of intention to create legal relationships. And I had told you in this particular case that a promise that there, if you remember this case, what happened in this case, there was a promise between husband and wife, and this promise can't be deemed as a contract. Why? Because intention of the parties was not to create a legal relationship. But it's not true that it's not true that all the family arrangements, if it's being made, they are not legally enforceable. The test in this particular case, the court dealt with a test of legal relationship, and the test is a very objective and not subjective test. While even if the family members are getting into an arrangement, what the court held in this case is the court has to understand and analyze what was the intention before entering into any kind of arrangement between the parties, because we already know that there is not always requirement of written communication, written notice or written agreement to constitute a contract. Even impliedly there can be contracts, as I dealt with. Not only that, implied contracts can be there, and also the family members can also enter into contracts. So in this case, what happened is a divorced woman was living in Washington with her son, where she was employed as an assistant accountant. So if you assume this is mother and this is daughter, I have used this picture to make it even more clear so that you understand. There is a divorced woman, and she was living in Washington. She was living within Washington with her son, where she was employed as an assistant accountant. She was assistant accountant at the Indian embassy, and she was on an attractive terms, means she was well paid. And her mother was in uh, Trinidad, and wished her daughter to be near her. And her mother wanted her daughter to to come to her place, because she wanted the mother wanted her to pursue her legal education. And later on, this arrangement did not work out. So what this arrangement meant, So the girl, the daughter was not able to complete her legal education, and also this means that this family arrangement did not fulfill, and her mother had also promised her daughter that she will pay her allowances or take care of her like education fees and everything. So this was the overview of the case. And this particular case, there was a very we see a very divided opinion of the court, because in this case the first consideration should be placed on the fact that the daughter had already had a job and she was working on a good terms, and because of her mother she had to leave her job. This was the first for the thing. And also there were questions because it was considered to be a family arrangement and there was no binding relationship between the parties. And at the end, finally the court had held that family arrangements are presumed not to be legally binding unless parties clearly intend to create legal relations. Ambiguity can invalidate contracts. So the principle followed was this, but this case holds a lot of importance. I took this case to make you understand that, but still, what you need to understand here is the daughter had to leave her already existing job, and the stakes were too high in this case, and there were certain elements in this case which can constitute a contract. But the court had held in this case that it does not constitute. But now I want you to look at this case, the case of merit versus merit. This is also deals with a domestic relationship. In this case, there were separating couples, and they had a written agreement. They had a written agreement in which a husband promised to transfer ownership of their matrimonial. Here, the house was matrimonial house to the wife at the time of the separation. And in this case, the court held this kind of arrangement, written agreement between the parties, to be legally binding. Because if you understand the nature and also the intention of the parties in this contract was to create a legally binding agreement means a valid contract. So it's fulfilling all the constituents. Whenever you're dealing with any case studies, understand that is the case fulfilling all the essential constituents. Is there was there a was there a valid offer, was there a valid acceptance, was there consideration involved, what was the intention of the parties before agreeing into the contract, what was the objective behind their agreement. Objective holds a lot of importance. Let's move on to the next case. So this case is Upton on Severin, uh, RDC versus Powell. This case deals with implied contracts. As I already told you that for the contract there is no requirement of a written agreement. It's not required that there should be something on paper. It can be implied also. This case is also very important, and if you want to like remember this case, you can remember this is emergency situation case. This is a code word we can use, because what happened in this case is Powell requested fire service to extinguish a fire on his farm. He was then billed for the service, but he claimed he was unaware of any payment obligations. So in this case, what happened? A fire broke out at the defendant. Defendant in this case is Powell. Powell is a defendant. The fire broke out in his in his farm. He believed that he was entitled to the free service of Upton Fire Brigade. and therefore summoned it. The brigade put on the fire. It then turned out that the defendant's farm was not within the free service zone, and he was under impression that this farm is under the free service zone. So he is taking the service of the fire brigade, and the services are free of cost. And thereafter, the fire brigade claimed compensation. Fire brigade, so they claimed compensation. Okay, what the court held in this case? The court held in this particular case that defendant wanted a service of Upton. He asked for the service of Upton, and Upton, in response to that request, provided that service. Hence, the service was rendered on an implied promise to pay for them. So, in this case, there was, even though he was under the presumption that it is in the free zone, but he took the service, he used the service, and the law presumes a reasonable expectation of payment for services rendered. So, there, even though there was no explicit, even though also this is under impression, and this is an implied situation. Okay, so the law presumes that there is implied contract which has formed between the parties, even though there is no there is no explicit agreement. There is no explicit agreement between the parties. They have not explicitly stated anything. Okay, so you understand the importance of implied contracts also, and we may and make sure you understand this, because we are going to use it for our very important wait a minute. Because we are going to use this principle for our very important concept of quasi contracts also. Quasi contracts. So come moving forward to our next case. So this is very much related to the case of Lalman Shukla, which we covered here. We here covered the case of Lalman Shukla versus Gauri Dutt. So this case is very similar, and it is also Indian case. Harbhajan Lal versus Harcharan Lal, general offer and acceptance. Here the court, even general offers as a term is not used under Indian Contract Act. That's why I'm saying that the understanding cases, reading cases is very important, and also incorporate these concepts in your answers also, so that it can help to it can help to solve, because in a lot of cases the Supreme Court and also other courts have given their judgments on these cases of general offer. General offer, what is a general offer and specific offer? So if you see, general offer is an offer which is made to the public at large. Public at large. So if you try to like think a bit, what are the general offers? We see general offers everywhere. General offer is what? Like if there is some notice put on and it's stating something, it is made to the society at large. And specific offer is what? When we are pointing out that this is the person to whom I'm entering into contract with. Specific person. So what this case involves, this case, Harcharan Lal advertised a reward for anyone who found his missing son. Harbhajan Lal found the son and claimed the reward, but Harcharan Lal refused. So Harcharan Lal, a young boy, ran away from his father's home. Harcharan Lal's son, so he ran away from his house. And then what the Harcharan Lal here in this case, Harsharan Lal is a defendant in this case, and what he did, he offered a reward in these terms: anyone who finds it and trace the boy and bring him home will get 500 rupees. He made a pamphlet and said that whoever brings the house bring his son to his house, he will give him 500 rupees. The plaintiff was at the dharamshala of a railway station, and so facts are not important. The thing is, the plaintiff in this particular case, case heard this notice, heard this announcement, and he brought the boy back to the defendant. And then defendant, he refused to give the reward. So in this case, case's plaintiff stated that he fulfilled the condition of this particular pamphlet, so it constitutes a contract. So he should be given the reward. So what the legal principle code dealt with, the a general offer is made to the public, and acceptance by any individual who fulfills the condition creates a contract. Harbhajan Lal's advertisement constitutes a general offer. What the court held this particular notice was to the society at large, and by fulfilling the condition was to bring back the boy. This condition was fulfilled by the plaintiff, which means that by performance, the plaintiff has accepted the promise, and therefore fulfilled the condition of the contract, and fulfilled the condition of the acceptance, and this creates a contract. So this is particularly is a principle of general offer. The court held that the acceptance is not required if the constituent of it's not an important constituent of contract is that this particular acceptance must be communicated, even though acceptance was not. Here in this case, acceptance was not communicated, but still it will constitute a valid contract because plaintiff has fulfilled the condition. I hope I was able to make this clear, that how it happened. So as we move ahead to a very important concept, which is, it's not generally taught as a topic, but I'm covering it because you should understand what is the difference between offer versus invitation to treat. We have already dealt even with the Bare Act definition of offer, and for your revision purpose, I'm stating again what is the definition of an offer. So offer definition is under the proposal section 2A, which emphasizes that there should be the expression of willingness to do or abstain with the view of obtaining the assent of the other. The offerer must have expressed his willingness to contract in terms of his offer with such finality that the other thing to be waited for is the assent of the other party. In this case, particularly, there are two parties. One is making the offer. He's proposing something. It is an expression of willingness. It is an expression of willingness. Expression of willingness is a simple word you should understand as an offer is. And in the offer, what happens is, one party is making an offer, he is proposing and is showing his willingness, and it is on the another party whether they want to accept it or not. But in the invitation of treat, what happens is, in the invitation of the treat, there is a public display, and it is for the another party to make the offer. To make it even more clear, let's go what is invitation to treat. Invitation to treat. In invitation to treat. In invitation to treat, one person invitation to treat. There is A and B. A has displayed some or product or anything at his shop. Okay, and B here is and this he A is not making the offer in this case. A is doing merely invitation to treat. Invitation to treat is he is inviting offers. And if B go to A to buy something, this particularly means B is making offer. This is basically a vice versa of offer. In the offer, what happens is A makes an offer to B and B accepts. But in this case, A is displaying the products and it is on the B. A is merely doing A is merely inviting offers, or what we call this concept as invitation of treat. And it is on the B who makes the offer. So it's important to understand that there are three kinds of invitation to treat. One is advertisements, another is auctions, and tenders. So in advertisement, what happens is there is invitation to treat, not offers. Binding contract only when the acceptance of specific offer follows. The person who is making advertisement is not making offer. You go to them, you go to them and offer. Once the person who is making that advertisement accepts it, then only the contract is formed. So auction, advertisement, and tenders are a invitation to the offers. The one who is making auction, even if when you see that when you go for auctions, auctioneer makes an invitation to treat, and the bids when you make the bids are a form of offer. And when these bids are accepted by the person who is doing the auction, then only it constitutes as the valid contract. Also in tenders, what happens in tenders, like the government tenders, whenever there is some construction project or anything, the government or other agencies, what they do, they are merely making invitation to trade. They are inviting people to make offer of tender. So when these contractors come and make the offer, these contractors make offer, and once this government accepts the offer, it turns into a contract. This the acceptance given by the person who is by the person, organization, or anyone who is inviting these treats, it constitutes a contract. Also one case where I want to state that this case deals with counter offers and contract formation. So Colonel D.I. McPherson versus M.N. Appanna. MC Ferson offered to buy land from Appanna. Appanna responded with a counter offer, changing the terms of the original offer. Here, the principle in this case is, if a party A make offer to party B and party B changes the terms of the offer and changes the term of the offer, then there is no valid contract. These counter offers negate. Counter offer rejects the original offer. So there is a new offer then. Once a counter offer is given, now B is offering A. Once it is accepted by A, then only it constitutes as a valid contract. Also, so in this case, a counter offer rejects the original offer and a contract is formed only when the new offer is accepted. Only when the new offer is accepted. MC Ferson's initial offer was not accepted. So as we come to an end of the session, you need to always remember the key contract principles. There should be clear proposal to enter into a contract. There should be unconditional agreement to all the terms. Whatever has been the offer, Acceptance should be of the same offer. There should be meeting of the minds of the parties. There should be some consideration involved, and this consideration should be valid. In subsequent videos, we will also see the what is a valid consideration. We have already dealt with. We will deal it with more cases. What is a valid consideration? When the consideration will be held to be invalid. Then we'll also deal with what is the capacity. The parties must have the capacity. We have already dealt with what comes under the capacity. Should be of the valid age, and others should not be prohibited by the law to enter into the contract. And I conclude this session by stating that we have covered the very important cases, revise these cases, um, and in the next video we will discuss the subsequent sections of the Indian Contract Act 1872, and I will also cover important case laws also. And finally, we will do some question also. In case you have any doubt in this, the cases which we dealt with, or any principles, or any in the Bare Act interpretation, so you can comment me. And in case you like this video, please subscribe this channel, like this video, and share these wonderful lectures with your friends. Thank you so much. I will meet you soon.